fill us in on what's going on. I'm John Lee with the St. Louis Real Estate Investors Association. Today is, let's see, what is it? October 23rd, 2020. So we're in the last quarter sneaking in here. So Kathie, what do we have updated as far as our courts and everything important to us?
Hi, everybody. It's good to see you all. I'm sorry to tell you we don't have a lot new this week. Chris is going to hop on in a minute, but I think that, our number one problem county is St. Louis County. That continues to be a problem. I feel like they were supposed to make the phase announcements every Friday, although we usually don't get them until the following Monday. But it seems like every Thursday there's another story in the Post-Dispatch about more COVID outbreaks in the jail, which the judge has been, I mean, if one thing he's consistent, he's, there's too many COVID outbreaks in the jail, so we're staying at phase one. The reason why this is important, you'll remember, is because when he goes to phase two, he's going to allow the sheriffs to start doing evictions. Or at least the stay on the sheriff doing evictions in the county is based on phasing, and they are stayed until phase two. We've heard a couple of times that they thought they were going to go to phase two, and then at the last minute, it's been recently COVID outbreaks in the jail there that have stopped it. And this, to me, is very unfair because the COVID outbreaks in the jail have nothing to do with the sheriff evictions. The sheriffs don't go in the jail. Those street deputies that do the evictions don't go in the jail. They're letting the deputies that serve papers, and that's more contact than the evictions are. So it's just one of those things. Our writ is to stop. That is still at the Missouri Supreme Court. Their next decision date is November 3rd. Unlike in the appellate court, where just one judge was able to tell us no, in the Supreme Court, they all vote on it. We are not sure if they are just not all decided yet or what's going on, or if they're just trying to put it off, hoping that they won't have to make a decision and that St. Louis County will go to phase two, before they have to do something. I would also point out that November 3rd is election day, and it's likely that the courts will be busy, especially courts at the level of the Missouri Supreme Court will be busy with election challenges and all the things. And I will tell you something about that. I do election protection on most elections where I volunteer to do different things. This year, I think Bonnie and I are going to be rovers and we're going to drive around together to polling places that are having problems. But, there's always a call center and there's always things going on. There's always things going on, even when it's not up and big in the news like it is this year, with a lot of issues. There are always people who, their registration is messed up or a polling place is locked. The school janitor forgot to come and open it, things like that. Polling places that get reported because they don't have anybody who will do curbside voting for the handicapped. I mean, there's always stuff going on. There's always a lot. But this year we're expecting to possibly be completely slammed with election day problems, or possibly nothing will happen at all. I think if I was going to give any advice, and this is nonpartisan advice, if I were going to give any advice to voters, I would say, if possible, vote early. If possible, vote at the Board of Elections. If possible, take a paper ballot because that's much less likely to be hacked than the e-screens are, or, have a problem. And vote early and, stop at the liquor store and prepare yourself for a long election night when you're on your way home. It's very possible that the lines on election day could be crazy. It's possible that they will have to close some voting locations because election judges, who are all 90 years old, right? They're not going to want to show up and get COVID being election judges. They won't be able to staff it properly. I would, I know I'm digressing from my usual topics, but yeah, so the Supreme Court might be very busy on November 3rd. So we're not even sure if we're going to hear about our writ then. Christine just predicted to me that she doesn't think that Judge Burton will let them do executions in the county anytime this year. Now, yesterday we had a big docket, and we do these dockets by Zoom. And I had a case that was set for trial yesterday, an eviction case that I was working with an attorney from Legal Services. And it was amazing to me. This attorney is we are kind of alike. We're very, we're huge pains in the butt. And um, she managed to get COVID money for the tenant, almost $4,000 from Arch City Defenders, which is one of the agencies distributing the money, and delivered the checks to my office yesterday. This is only really the second one that we've actually gotten physical checks on in St. Louis County. And I was very impressed and pleased. My client said, give me the name of that attorney because I'm going to send all my other tenants to her. So it's Sarah Turner at Legal Services. And I was really pleased that some of that money is getting out. However, we've had reports from other clients of just incredible boondoggles, time wasting, agencies that aren't returning calls, losing tenants' paperwork, that kind of thing. We do believe that some of the tenants are sincerely trying to get the aid. They want to get the aid, but they may be, experiencing log jams with this. We're happy to get involved and help you. You might need to get involved and help yourselves with those agencies. And I really appreciate people who are emailing me anecdotal evidence of their process in getting the CARES relief money for their tenants' rent. I'm going to share some of these stories with Judge Burleson in a week or so when he's making the decision for the city about whether he's going to extend the current eviction stay. And just to recap what's going on with the city, Judge Burleson extended the eviction stay through November 6th, but he accepted pretty much everything except rent cases. He accepted everything that's accepted from the CDC order. So we can evict unlawful detainers, 441s, and other kinds of evictions in the city. And I think in some cases where we already had judgments for those kinds of cases, we had to go back and get additional orders. I think I'm going to call on Chris now to talk about that part, but we are able to do some of our evictions in this.
All right,
Chris, you're breaking up. Can you talk about the evictions in the city, what we can and can't do?
Yes, obviously, like Kathie said, the only thing we can move forward on, anything besides not rent cases. If you are moving forward with any cases there, you have ones already that were for unlawful detainers, you do have to get a special order from your trial judge as to stating that it is based upon some sort of violation other than non-payment of rent. So it takes a little while longer. I was able to get it done, but I suspect unrepresented parties might have a harder time doing that with judges not trusting what they're throwing out there. But we are moving. I've got 3 unlawful detainers scheduled to be evicted next week. So we shall see. Hopefully they get out on their own and we don't have to worry about it.
Well, I think those
you
of
get them in
you
front of a judge, make sure that
experience with evictions know that, you get that sheriff paperwork going out and posting on the door, and a lot of tenants will move then. I'm sorry, Chris, I think I somehow stepped on your transmission.
No, I don't know. Maybe I should log off if we're having too much bandwidth being used this morning, but you and I are having a hard time with the internet.
Yeah, I don't know. Do you want to talk real quickly about what's new in Jefferson and St. Charles?
Nothing since last week. Everything's with landlord tenant cases, everything's moving pretty much normal there. So you can keep doing whatever you want to do out there for the time being. I'm sure Jefferson will get locked down again at some point.
I went to court on Wednesday in St. Charles, my first time being in court since March. I felt very new, like it was, the 80s again. And I had a default on a commercial breach of lease case. And I felt like St. Charles was handling it really well. They have a new courthouse, fairly new courthouse. So hopefully fairly new HVAC, big courtrooms, big hallways. Everything is big and clean. Temperature checks and mass checks in addition to security going in. And they also checked you on a list to make sure that you actually had a case on that morning before you could go in. The halls were empty. I was in a large courtroom with maybe 6 other people plus the court personnel, and I got in and out fairly quickly. So that went great, but it wasn't the big that wasn't the setting of a big docket like we're used to have. And it's still anybody's guess, I think, about when those big dockets are going to pick back up. Let's talk about the CDC for a minute. I think that John has posted the CDC order and then the clarifications on the website. So we pretty much have been just forging ahead on our evictions, even when the tenant does a declaration, going all the way up to judgment. We think that the only thing the CDC order prevents us from doing is the sheriff executions, which for the most part, we can't really do right now anyway. So we're just going ahead and getting our judgments. And we had several people yesterday on our docket that I talked to who had CDC declarations, but they were still willing to enter into a consent judgment and a payment plan, which is really what that order says they're supposed to do. So we were doing it in the hopes that we would at least maybe they would start paying our clients some money. Something's better than nothing. I sat in on the federal court hearing on Brown versus Azer in the Northern Georgia District and Federal Court on Tuesday on the oral argument on their the plaintiff in that case. There's a number of plaintiffs now that have joined in, a bunch of landlords who are attempting to stay or set aside the CDC order. The arguments were interesting. I thought the lead attorney for the plaintiffs for the landlords did a good job, as did the attorney for the CDC. And I just checked online this morning. The judge took it under submission and he has not ruled yet. The judge did not ask a lot of questions, which I thought was interesting. Here in federal court, it's what they call a hot bench. You expect to get asked stuff. There, he kind of mostly listened. So I feel like I don't have anything new. I hope everybody is doing good. I would continue to ask you if you are having interactions with these agencies trying to help your tenant get CARES money. I'd like to know about those because I'm going to bring that up to Judge Burleson in our next phone conference about whether he should extend the stay in the city. You'll recall that in the city, Judge Burleson has been extending the stay to allow people time to get this money. And, we think it's time to end the stay and put a fire under all these agencies to get the money to come out or get the tenants to apply for it. Does anyone have any questions?
We do.
Okay.
Thank you. This is my husband, Paul, and I'm Kathie.
Hi.
Hey. We live in Jefferson County and have one rental house in Jefferson County. And our problem is not that the people that are renting are behind. They're up to date on their rent. Thank you, Jesus. And our problem is we want to sell the house. And we have rented to them for a year and a half. The first year we signed a 1-year contract with them. Since August 1st, we have been on a month-to-month contract, even in our contract stating that at any moment, all we have to do, either them or us, has to give a 30-day notice. Now, they are paid through October 31st. We sent them a letter stating that we want to sell the house, and they turned into people we don't even recognize, as you can imagine. So we need a little advice on where are we at, what do we need to do? They are in violation of the contract. They're smoking in the house. They have a dog. They're smoking pot in the house. We believe their daughter has moved in with them, but we can't prove that. So we just want to sell the house outright. So we need advice on what do we need to do, where do we need to go, and all of the above, please.
I'm going to let Chris hop in on this because he's our Jefferson County lawyer.
Yeah, so you've got some pretty straightforward options. Really the easiest one, maybe not the quickest one, but the easiest one would be before the end of this month, you would need to serve on them a termination of tenancy, giving them their 30 days till the end of November. that needs to be hand delivered to the house. So either, if they're there, great, you hand it to them. If not, you tape it to the door, and it needs to say we're terminating your month-to-month tenancy. You've got until November 30th to vacate. Come December 1, if they don't leave, then you can refuse their rent if they try to pay it and sue them. And it'll take you, with the holidays, you probably wouldn't have them out till sometime late January, but you wouldn't have to prove anything. I mean, it's pretty much, all you had to prove was you were on a month-to-month lease and you terminated them. If you wanted to be a little quicker, because they've violated the lease, you could give them as little as 10 days notice for the lease violations. You would have to put on your notice that, you probably, I will preface that by saying you really want to check your lease. Some leases say you have to give 30 days notice if there's a violation. If it's silent on the issue, the state law defaults to 10 days. So you want to check your lease. If it says they have to give, it's always 30 days notice, you might as well just do the termination of the month-to-month tenancy. The 10-day one, if you can go that route, you would have to sue them still, and you would have to prove that they violated their lease with the dogs and the smoking and stuff like that. So it really depends on, is the 20 days or 30 days difference from you worth the having to actually prove something at trial and getting a fight about whether or not they're smoking in the house and whether they have dogs and who's living there. So it really depends on how quickly or how much need you have to have a real quick out, or if you're fine, if you're fine with not, you're going to sell it sometime next spring, then I would say just go the simpler route and hope that because the one nice thing about the longer termination period is they may actually get out. No one gets out in 10 days, but people sometimes do get out if you give them the full month. Mm-hmm. So they may be mad at you, but they may get out. So depending on how quick, if you have a real pressing need, it may not get you there because of the holidays. It may honestly not get you there any quicker to do the shorter route right now. It's always around this time of year. Once you start filing, you pretty much count on them, anyone being in there until around January or so, just because no one does anything around Christmas.
Okay. And let me add a couple of things, Chris, if you don't mind.
Sure.
We did notify them. We sent a registered letter out to them that they signed for back in beginning of October. Mm-hmm. And we told them they had the 30 days, but we gave them till November 8th at midnight to get out. Okay. And so we did legally, we believe, went through the right channels. No, we're not in a big hurry. Mm-hmm. But we've been dealing with them. We notified them when they moved in without us even knowing it. Their daughter had rented from us previously, and they moved in and then came to my office and said, "We moved in." What? So it's just really, this has been, they're great payers. I have to give them that. Now, mm-hmm. My other question is, if we go the longer route, do we have to accept their November rent, or should we, or what should we do?
You should accept your November rent. That doesn't hurt you at all. Going back to your technically your notice of termination by the letter of the law is ineffective because a month-to-month tenancy, it's not just 30 days, it's 30 days from the date the next month starts. So if you did it on October 5th, you'd have to get them all the way till November 30th. The other part where the state law differs from what you did is that it says it needs to be hand delivered. Now, I found some case law recently that gives me some hope that I could possibly win an argument that that them signing for a notice means that they have proof of delivery, and that trumps that. But if you wanted to be on the safe side, the simpler side, particularly if it looks like they're not going to be out by November 8th and you're going to have to sue them anyway, I would re-terminate and give them to the 30th. Might give them a little bit, okay, they're being nice to us. Maybe they actually leave voluntarily and don't turn it into a big fight. If you think there's a chance they could be out by November 8th, you may want to wait to the last day of October to do it, to see if, maybe they, if you see them packing up and moving, or they tell you, I want my security deposit back, I'll be out by November 8th. And then, maybe you don't do, you don't go ahead and tell them November 30th on the hopes that, they actually just leave. Mm-hmm. But I'd probably re-terminate and just go the 30 days out, give them November 30th, and make sure someone goes to the house and either tapes it to the door, hands it to them.
Who delivers that? Who do we don't want to do it. Do we hire somebody to do it or just go through the
I
sheriff?
mean, you could hire us to draft and do it. That's certainly that. I mean, you could have a maintenance guy go and do it. I mean, it's really, the one thing is if you have someone else do it who's not a process server, then you're going to want to make sure it's someone who could be willing to testify that they did it if it got challenged, at court. So someone you trust. And I see someone in the chat said you could also sell the building to someone who's willing to buy it with a tenant in it. That really, with a good paying tenant, she is right. Some land buyers are interested, if they're buying it as an investment property, to buying it with a tenant in there. So it's possible that you don't necessarily need to, depending on which market you're trying to sell at. And I'm certainly not a real estate agent, but I have had clients who have sold properties with tenants in there.
Mhm. We tried that last spring, and we really just we decided it's not in our best interest to go in that direction. We just want to be,
Yeah. So what I would do then is I would go ahead and re-terminate, make sure both their names are on it, make sure you don't have to serve both of them, just one of them, at the house. And, I said, if you want to give me a call, and have our people do it, so you don't have to do it. I think we only charge 130, depending on where it's at, in Jefferson
it's on
County.
Moore Street in Festus.
Yeah, I mean, it might be $140 depending on how much our process server charges between what we do and what they do to be out there. And they'd come out there and they do it and make, sometimes when an attorney does it, they make it seem a little more official that, now my landlord's not going to back down and,
Right.
they're serious about it.
Well, we need your phone number, Chris.
All right, you ready?
Yes.
314
Mm-hmm.
962
Mm-hmm.
1115. And if you get our voicemail, it's extension 15.
Okay, we appreciate that.
Yeah.
Yeah, we just want to get the show on the road, and be done with it. And we want to make sure we've got I's and crossed T's.
Yep, give me a call and I'll get you everything you need to get started.
Absolutely. So I want to make sure that this is clear. And we've been driving by the house. We're trying not to harass them because we don't want that ordeal. We've been driving by the house, and there's no activity as far as them moving, and as far as we can tell,
Right.
that
The last couple times we've been by, it's no cars in the driveway. No, it's possible they've been out working, but nothing, no activity at the house.
Mhm.
Well, if you go by there again, you don't see them around there. I mean, you're well within your rights to, if you have a key to the place, to go in, knock. If no one answers, unlock the door and poke your head in and see if they vacated. It's possible.
Locks.
Okay. Well, I mean, yeah. Other than that, it's look through the windows, and that's kind of where you're at until you actually go through the process.
Mhm. Yeah. Well, and they got a pit bull too. So,
Ooh.
Well,
and it's against the lease, and I just
well, the one nice thing about the dog is if you knock it, it's going to make noise, so you'll know for sure if they're in there.
yeah. We're just afraid, if we go by, because he sent my husband a really mean text and said, of course, right, we ruined their lives. He stated that, leave us alone and stuff like that.
Yeah, well, my process server is not scared of much, so we've certainly dealt with difficult tenants. So they'll tell us if it looks like they vacated as well.
Okay, we'll definitely call you off, when we're done with the phone.
All right, great.
Thank you.
Okay, guys. That was good, guys. Does anybody have anything else for us?
Great update, Kathy. I mean, it's amazing what you're out there doing every day for us.
Well, we appreciate you guys a lot, and we hope that you're all doing well.
Yeah. Thank you so much.
What's your extension, Kathy?
My extension is extension 11,
Okay.
and
I'm gonna
Chris
call
is
you.
extension 15.
Yep, got it.
Okay. Okay, we're gonna leave you. Thank you. We'll see you next week.
Thank you so
Bye,
much.
guys.
Appreciate it. Thank you.